Good day. I'm Cyrus Mansouri. I'm a matrimonial law solicitor and I practice in England and Wales. This podcast is dealing with the Acknowledgement of Service form. This is the third podcast in our series called Managing Your Divorce, and it will take you through all the various stages of managing your own divorce under English law. What I'm going to deal with today is going to be more relevant to probably the respondent, that's the person who's on the receiving end of the divorce, than it's going to be to the petitioner. But it's still going to be, there's points I'm going to cover that will be important to the petitioner too. But I think the respondent is the person who's going to be more helped by this guide today. So where we are at the moment, if you watch the previous podcast, is that the petition has been filed at the court and it's been issued by the court. That means it's been given a case number and the court has sent it out to the respondent. Now, once it's issued, the court will only ever post it. They're not going to do any other means of service because there's other ways of serving people. The reason for that is because the huge majority of people will simply receive it in the post. They'll do what it says on the form, which is you've got 7 days from the date that you received the acknowledgement of service form to return it to the court. And I stress it's 7 days from the date you received it, not the date that it was sent or dated or whatever. The court just works on the basis that most people will do that. But of course, occasionally we have situations where the respondent isn't going to fill it in and they're not going to return it to court. But I'll also talk about that. The other methods of service are to ask a bailiff from the court to physically, personally take the divorce petition and the acknowledgement of service and to serve it on the respondent. There's a fee payable for that, and you also need to fill in a form called a D89, which is an application for bailiff service. Now, the good thing is that deals with situations where the respondent is not very cooperative and they're not filling in the form. The bad thing is that the bailiffs will do it when they've got a time to do it, which will often mean that there'll be a long wait because they've got a list of other things that they have to deal with. And they will also only visit on a limited number of occasions. So they'll only try to serve it 1 or 2 times before they come back to you and they say that they couldn't find the respondent. And if you want to take it any further, you'd have to pay the fee again or go down some other route. And that other route is to have the papers served yourself by an independent bailiff or what we call a process server, which is similar to a private investigator, and you would pay them to serve it for you. But of course the problem here is that you have to serve the divorce petition with the acknowledgement of service form, and you won't have that as a petitioner at this stage because it only gets sent to the respondent. So you'd first need to obtain that from the court. The acknowledgement of service form is also known as the D10. All court forms for divorce subjects, they all start with the letter D and they've got a number after them. It's called the D10. And it's generated by the court system. So it's not a form that somebody can go online and find and fill it in or that you could photocopy and supply them with. It is specifically printed for your divorce. So if you're the respondent, that will have arrived in the post or it may have been handed to you by a bailiff or a process server. And you need to fill that in. But if you're the petitioner and the respondent appears to be ignoring your divorce, which is quite a common occurrence in a small number of cases, but it's quite common, then you're going to need to ask the court to give you the acknowledgement of service form, and then you're going to have to arrange for it to be served. Now, I should point out at this stage that if any of you are wondering whether you can do the serving yourself, you can't. The petitioner cannot serve the respondent. Pretty much anyone else can, as long as they're an adult and they're of, as the law says, of sane. They've got capacity. In other words, they're sane mind. But anyone else apart from you can do that, but you can't. But that is a more complicated area, and I think that if you're in that territory, then again, that's one of the flags where you might be thinking that it'd be a good idea to get some proper legal advice, because it's not quite as simple as I've described it, but that's generally how it would work. Now, the 7 days that you as a respondent have in order to fill this form out, it runs from the date on which you received it. Uh, if it arrived on a Friday, obviously it's 7 working days, so you've basically got something close to 11 real days to fill it in, because obviously Saturdays, Sundays don't get counted, and if you factor in bank holidays and Christmases and things like that, then that 7 working days can, potentially be quite long. The reality of the situation, if you're a respondent, you're watching this, you've just received your acknowledgement of service form in the post, maybe it's all come to you as a bit of a surprise, you weren't expecting it. The reality is, don't panic, okay? Especially if it came in the post. If you return it a bit later, nothing much is going to happen. You've got time. Get your legal advice, or go and do your reading, or if you're on talking terms with your partner, phone them up, talk to them, resolve the issues that you've got, send it back. I can't be advising people to ignore court timescales, but this is one where if you are a bit later, it's probably not going to result in any serious consequences. Judges won't like me saying that, but it's a reality. There are situations in which it can be a problem, and that's particularly if somebody served the acknowledgement of service form on you in person. That's if a process server or a bailiff showed up at your home or at your office, or the place where you work, and they handed it to you. Even if you didn't accept it, even if you threw it straight in the bin, or you just fell on the floor and you walked away, that's a different situation. Then you are really up against the clock with that, and I think timelines are going to be very important in that situation. So don't be blasé if that's what happened, but if it came in the post, there's some flexibility there. Now, this needs to be returned by the respondent to the court for this divorce petition to go any further. The fact is, no divorce petition is going to progress unless the acknowledgement of service form comes back to court, signed either by the respondent or by the respondent's solicitor. If the petition was based on the 2 years separation ground with the consent of the respondent, which I talked about in part 2 of my podcast, which dealt with the facts of a divorce. If it's based on that, the respondent is going to have to agree to this divorce. There's a question, and I'm going to come to that in a moment, but they're actually going to say, they're going to have to say, yes, I agree with this divorce. If the divorce is based on any of the other 4 facts, which I explained in part 2 of the Facts of Divorce podcast, then they don't need to agree, but they still need to return the acknowledgement of service form. So even if they write on it, I absolutely do not agree with this divorce, and they give whatever reasons it is that they don't, it's got to still come back to court with their signature on the back, because if that doesn't happen, the fact is, as far as the law is concerned, they haven't been served. And if you're in that situation where your respondent is not returning the form to court, again, flag, you need to think about talking to a lawyer, because you can do it yourself. There's nothing that you cannot do, but it is complicated. And if I wanted to go into describing how to handle that in this particular podcast, it would drag on probably for an hour. Maybe one day in the future I'll do a podcast dealing just with that subject, but at the moment I'm not going to get stuck on it. So that's another flag where you might think you need to talk to a lawyer. So moving on to the form itself, I've got a form here, an acknowledgement of service form. It's going to look a bit like that, okay? It's two-sided, and I'm gonna take you through it. It starts with the basics at the top there, where the 2 black lines are. The names of the top name will be the person who petitioned for the divorce, and the name underneath it is going to be the respondent's name, probably your name watching this. And then under that, on this particular form, you can see they've written unknown. Underneath that is a space for the name of the second respondent, which is only going to apply in cases of adultery. And that's if the person got named. Very uncommon, very unusual, but if they did get named, their name will also appear there as the second respondent. And up here, in this corner where there's this black line, that's going to be your case number. Now, this acknowledgement of service form consists of basically 9 questions, and they all have to be answered by the respondent, and I'm going to take you through them. The first question, it's split into 3 sections. It's called 1A, 1B, and 1C. 1A is asking the respondent, are there any other proceedings in any other country that are related to your marriage? For the huge majority of people watching this, the answer to that question is going to be a simple no. It's a great big gap of a space there for you to put the answer in, and you might think that you're expected to write a lot, but the answer is just usually going to be no. If there is a case somewhere in the world that's connected with your marriage, then you're going to need to write it in here, and it goes on to ask you lots of questions about where it is, what the case number is, what the name of the parties are, and ask for dates. And if you do end up answering yes to this, you will have to supply copies of that case when you send in your acknowledgement of service form back to court. And if those documents that you're supplying are not in English, then like everything else, you're going to have to supply English translations of them too. So that's question 1A. Most of you are just going to put a simple no there. 1B, it asks you where your place of habitual residence is. Okay. Now, so often I get these forms returned by respondents and they will write United Kingdom in it. Okay, that's not a mistake. Okay, because it gets tidied up by question 2, and I'll get to that in a moment. It's not a mistake, but it's also not exactly accurate. There are actually, the proper name of the country that we're living in is called the United Kingdom of Great Britain and Northern Ireland. A bit of it that I'm a lawyer in is called England and Wales. I'm not a lawyer in Scotland. I'm not a lawyer in Northern Ireland. And they've got different legal procedures that apply to those countries. So where it says to you, in which country are you, this is question 1B, habitually resident or domiciled, or of which country are you a national, you would normally want to write either England or Wales, assuming, of course, that that is the right answer. Now, if you're wondering what habitually resident and domiciled means, they do have complex meanings, but they've also got quite straightforward meanings. Habitual residence is basically the country where you consider yourself to be living. It doesn't have anything to do with your immigration status. It doesn't have anything to do with a lot of other things. If you think in your heart you live in England or in Wales, then you're habitually resident there. Those other matters are separate issues. Domicile, well, that's a bit more complicated. We normally are all domiciled in the country where we were born and where we have a passport, a nationality for. That's our normal place of domicile. But domicile can change if we leave that country and we come to Britain and we get a British passport, then we can have either a new domicile or dual domicility. So you can be domiciled in the UK because you've got a British passport, but you can also be domiciled in some other country because you were born there and you also have their passport. But as long as you're living in England and Wales, the answer to this question is going to be England or Wales, whichever one you prefer. You can also write England and Wales because legally they're both the same thing. Moving on from that question, the question 1C, which is the last section of question 1, is, do you agree with the statement of the petitioner as to the grounds of jurisdiction as set out in the petition? Sounds very complicated. Basically, the petitioner, when they filed the petition, they said that they had a right to file it because either they or you live in England and Wales, and this is asking you, do you agree that one of you or both of you lives in England and Wales? And as I said, for the huge majority of you, the answer to that question is also going to be yes, because that's where you're going to be living. If there is a dispute, if you feel that, well, no, I don't live in England and Wales, I live somewhere else, and so does the petitioner. You know, why are they petitioning for divorce in this country? We don't live here. Well, then this is where you're going to have to need to put down a no, I do not agree, and you're going to have to add in a sentence and explain why. And that could potentially have a big effect on the divorce petition. But for most people, it's just going to be yes, I do agree. Question 2 is a simple question. On which date and at what address did you receive the divorce petition? Just put it in, the date you received it, address where you got it. It's normally going to be your home address. If you got served by a process server or a bailiff, maybe they showed up at your work or something, put that address down. It just confirms to the court that you were served, really. That's the purpose of asking that. Question number 3, are you the respondent? Well, sounds ridiculous, doesn't it? But you'd be surprised. As long as you're the person named on the divorce petition, then the answer to that question is also going to be a simple yes. You are the respondent. If they've managed to completely spell your name wrong, incorrectly, then you might probably venture and say, no, I'm not. The person named there is somebody else. And you'd be well within your rights to do that if that's happened, but it doesn't happen all that often. So, question 4. Now we're getting into the real meat of the acknowledgement service, because this is the one where most of you are going to be having a lot of questions about. And it's basically saying, do you intend to defend the divorce? For the majority of people, the answer to that question will be no, I don't. I'm not going to defend it. You know your divorce, your marriage has come to an end. You've probably talked about it, and this divorce petition is probably not a big shock. But if it is, then that in itself is quite a strong message, and it's telling you that there's obviously a very big problem. So, as I said, most people are just going to say no, I don't intend to defend the divorce. But what I do get very often is respondents getting very upset about all the reasons that the petitioner has put in the divorce petition about them, all the sometimes the very nasty things that have been written there. And they'll often turn around and say, yes, absolutely, I'm defending this divorce. I'm not agreeing to anything, because look at what's been written about me, a whole load of horrible things. Well, you have a right to defend it, and I'm not going to talk you out of it. But I will say that there is a simple solution. What you can do as a respondent here is in answer to the question, do you intend to defend the divorce, you can say no. And then below it, you can simply write, however, I deny all of the things, the grounds that have been written, all the particulars they're called, that's the correct word to use. I deny all the particulars that have been set out in the petition about me. So what does that mean? That means you haven't admitted anything as a respondent, but you've agreed to the divorce going ahead because you accept that, well, our marriage is over. Perhaps it's not over for the reasons that have been written, but you do agree that it's over. So you can simply just agree at this point and let the divorce proceed without a fight, without any conflict, and you've denied everything that's written in it. So in a sense, you've protected yourself. There's no admission. And I can tell you that in the huge majority of cases, the particulars that are set out in the divorce petition are, for most times, are not going to have an effect on the finances or custody of the children. It's going to be rare occasions that they get looked at and they're considered to be taken into account. So generally speaking, you can comfortably deny everything but agree to the petition going ahead. So it's going to be a simple one-word answer to that question, or it'll be the one-word answer, which is no, I'm not going to defend, but I deny everything that's written about me. If you are going to defend, then this is another one of the flags. You're going to really, I think, need legal advice. Defending a divorce petition is rare. I've been doing this work for 30 years now, and I think I could just count on probably on both hands the number of times I've had people defend these. The main reason is because it's going to cost a lot to defend a divorce petition, and ultimately, what are you going to gain from spending that money? Because no matter what the court decides at the end of that case, if your spouse doesn't want to live with you, then your spouse is not going to come back and live with you, even if the court rejects the petition. you know. So you have to ask yourself, well, what am I going to achieve? Sometimes we've had situations where there's a genuine legal issue why we would want to defend a petition. I'm not going to get into that because it just applies to such a tiny minority of people who are involved in this. And again, maybe one day I'll get around to doing a podcast about it, but it's not something that most people are going to worry about. So, one of the considerations, if you're thinking of defending it, is the cost. The other one is that the minute you tick yes there and say, yes, I am going to defend this petition, you invoke some very, very strict timelines and timescales in the whole process, which you're then going to need to comply with. You're going to have to file a form D8B, which is basically it's an answer. It's called an answer to a petition. There's a strict timeline for doing that, and once you do that, you're going to end up with a court hearing, and there's going to be costs involved in that, and it's also going to be one of those situations where the successful party at that court hearing is very likely to get their costs against the unsuccessful party. So even if you're walking into this without a lawyer, if your spouse has got a lawyer, and you end up losing that application, you could easily end up with quite a significant costs order against you. So you do need to weigh this up, and as I said, it's one of those red flag situations where I think you should take some independent, proper legal advice on the subject. Moving on now to question number 5. If adultery was cited as one of the facts by the petitioner, then question 5 will apply to you as a respondent, so you're going to have to answer that question. If adultery is not part of the petition, then it's not relevant, and anyone who's being divorced for unreasonable behavior or 2-year separation or desertion or the 5-year fact can ignore this question. It doesn't apply to them. But if adultery has been cited, then it does go on to ask you whether you admit it. Now, it's if you have if that's the situation you're in and the petitioner has cited the fact of adultery, and if you are thinking of admitting it, be careful, because this is one of the rare circumstances when there is a small possibility that it could have an effect on the financial settlement. It all depends on the circumstances. A court would need to come to the conclusion that your behavior was really over the top for it to affect the finances. It would have to be very extreme. So I tend to usually advise clients that ordinary, one instance of adultery or a short period of adultery is probably not going to make much impact on the financial side of things. But if it's anything more than that, then you probably need to think about taking some advice on it. So that question, as I said, only applies if adultery is relevant, and if not, everyone else can just put an NA there, not applicable. Moving on to question 6. Now here is probably the most contentious section in the whole form, which is, even if you do not intend to defend this case, do you object to paying the petitioner's costs? That's the question. I think unanimously, probably everybody filling in the form is, yes, of course I object. I don't want to pay anybody's costs. Well, this is a very difficult area, because for the most part, the petitioner is normally going to get an order for their costs to be paid by the respondent, if they asked for that, which most of them do in the original petition. And for the most part, they're going to get that. Now, writing down here and saying, yes, I object, does not mean that you won't be ordered to pay it. It simply means that you'll be given an opportunity to explain why. And that opportunity needs to be set out in this form, because the same question says, if you are objecting, tell us what your grounds of objection are. It's right back down there at the bottom. So you're going to have to write it out. Saying things like, I'm broke, or I haven't got any money, or I'm on benefits, or pretty much anything, not necessarily going to help you. So the fact that you don't have the money is not in itself a defense. This is the reason why I always try to encourage clients to be as amicable as they can be in their divorces, because when it comes to the issue of costs, you could have negotiated it before anything even started, and you could have had an adult conversation together and said, okay, you petition for the divorce, I'll be the respondent, but I'll agree to everything you want on condition that you don't ask me to pay your costs. Or on condition that we'll pay your costs 50-50. Okay, you pay half of them, I'll pay the other half. It depends on your situation. But that's one of the reasons why being a little bit amicable and a bit cooperative can pay off. Because if you're not, or if the petitioner is just not very themselves cooperative, you can end up in a situation where they are going to throw their legal bill onto you, and the court's going to order it, that you pay it. And some solicitors who represent some of these petitioners, their costs are, I shouldn't say it, but they're high. They're very high. I struggle to justify some of the things that I've seen. We tend to do a fixed fee divorce for just about everybody, and it's usually £800, and we add the court fee to that and VAT. But I've seen other lawyers represent petitioners, and when it comes to this issue of costs, I've seen them putting up £3,000 bills and even more. And I have to say that leaves me very uncomfortable, because it's not £3,000 of expense to get a divorce. But of course the problem is when you're the respondent and you're on the receiving end of this court order, you don't really get any say in it. It's either you have to pay it or you don't. And how much the bill is, the court doesn't always get too involved in that. They'll just say you've got to pay it. And the fact that it seems ridiculously high is not necessarily going to be much of a defense. So it's an important point. You need to really try and argue it out here, and it would help you if, even if you haven't talked about the divorce before you got the acknowledgement of service, it's a good idea even now, if you can, to call up the petitioner or make some form of contact and say, look, I've got this form, I'm ready to agree things, but you've got to come to an arrangement with me on the costs, because I can't afford it, and try to negotiate. It's not always going to work, because emotions will be running high, but it's worth trying, and I know a lot of people who succeeded. So that's that one. The next question is question 7. Now, for most people who get an acknowledgement of service form, there'll be nothing on that, nothing written in that box. It just says omitted, which means deleted. The reason is because it used to be used in relation to the subject of children and arrangements that were being made for children. Now, the laws changed, those forms no longer need to be filled in, and the acknowledgement of service form has not particularly been updated. So for most people, it's nothing. There's nothing to answer. It's just not applicable. In fact, it tends to get printed with not applicable written there already on your behalf. But if it's blank, you can write not applicable in there yourself. That question 7, if there's a very particular situation relevant to your divorce that's something out of the ordinary, sometimes the court can put in another question there relevant to your divorce. Very, very rare. But if it is, then obviously answer whatever the question is that's been put in there. Now, question 8. A lot of people laugh about this. It talks about polygamous marriages. Well, they're not as unusual as you might think. What is a polygamous marriage? Well, for those of you who don't know, it's basically where one person has more than one spouse at the same time. You may think that that doesn't occur in England and Wales, and you'd be wrong to think that, because it does. Legally, people cannot marry more than one person in England and Wales, but they can be married to other people through other means. They can be religious, they can be cultural, they can be some other form of arrangement. And there are many minorities that do have more than one spouse at the same time. If that is your situation, which I very much think would be unlikely, because again, it's one of those rare situations, but if it is your situation, then they're going to want you to name all the other spouses in this relationship in answer to question number 8 on the Acknowledgement of Service form. Very unusual that anyone's going to have anything to say there, but if it applies to you, that's where it comes out. Now, question 9, that's split into an A and a B. 9A is where you, the respondent, will normally be signing the Acknowledgement of Service and putting a date on it and sending it back to the court. If you don't have a lawyer acting for you, then it's 9A. Sign there, date it, post it back to the court. If you've got a lawyer acting for you, they'll normally sign section 9B on your behalf. They'll return it to the court. However, if the petition was on the basis of adultery, you've got to be yourself, the respondent, you have to sign section 9A. Because if it's adultery is the allegation, they need your signature on it, not your lawyer's. So it says that on the form, so you don't need a great deal more explanation from me. But most people who are watching this podcast probably don't have a lawyer, and they're going to be signing section 9A themselves. Now, when you've signed it up, what do you have to do? Well, you stick it in an envelope, post it back to the court where it came from. That it's got the court's address at the bottom of the page. This particular one that I'm showing you comes from a court called Bury St Edmunds, which we nickname it as BSE. The divorce system has been split between approximately 3 or 4 centres across England and Wales, and all divorces are being processed in these. There's one in Portsmouth, there's one in Liverpool, and Bury St Edmunds is covering the London area and generally the Midlands. You're free to petition your divorce in any one of these, but if you don't pick one, normally the system will allocate you to whichever court tends to be closer to you, closer to your home address. You return the form to that court. At the moment, it's postal and it's done by way of an envelope. Gradually, they're moving the system online. The system is online for the petitioners. It's coming online for the respondents, and you'll get to the point where the Acknowledgement of Service form will have a online code, which is just for you, and you can log in, create an account, scan your Acknowledgement of Service form and file it online. Possibly even one day there won't be a form, maybe you'll just fill it in online, but we are going in that direction. But at the time of making this podcast, which is 24th of September 2020, it's still postal. Now, that I think covers most of the issues that deal with the Acknowledgement of Service form, apart from a couple of satellite subjects such as, my spouse won't return the form, what can I do? As I said, I'll try and deal with them separately in another podcast when I've finished the divorce series. I'll do some sort of smaller subjects, problem areas when we get there. But for most people, what I've just set out is the only involvement that you, the respondent, was going to have at any stage in this divorce. It's filling in this form. Beyond that, you really have no other role in this divorce, and the ball now gets kicked back into the petitioner's court. And the next stage and the next podcast that I'm going to be dealing with is for the petitioner again, and it is going to be what do I do when my partner, my spouse, has returned the Acknowledgement of Service form to court. What do I do next? Basically, that's your application for a decree nisi, and in the next episode, I'll go through how you do that, and the forms that you're going to need. And I'll talk a little bit about how long it takes, because there's quite a lot of delay in the system at the moment. When I'm recording these podcasts, we're still at I dare not say the tail end. We're in the COVID pandemic. It's September. It's been running for 6 months. Nobody knows what the future's holding, and all of the courts and the court systems have been quite badly affected by what we've had, which has been several months of complete lockdown. And this is obviously going to impact the speed at which people are getting their divorces processed. And that impact is likely to last for a while into the future. So it's difficult to give any timescales now, but I'll talk a bit more about that in the next podcast. I hope that this has been helpful. We're providing this information. Obviously, it's all free, and all we can ask you for in return is if you'd click a like for us on this video, and if the subject is interesting to you or relevant to your life, if you would subscribe, that would be wonderful. Thank you very much for watching, and I look forward to speaking to you again in the next podcast.